You listen to me right now. A judge shuts down the courtroom as a defendant accused in a Michigan assault case asks for release on a personal bond. But when concerns about his mental health and frightened victims surface, the judge delivers a serious warning that could send him straight back to jail if he crosses the line.
All right, this is 253737SM, the state of Michigan versus Destin Kirk.
Yes, good morning. Todd Baird appearing on behalf of Mr. Kirk, who's appearing from the Wayne County Criminal Justice Center.
And good morning, Your Honor. Nora Ali on behalf of the people.
Judge, the matter was scheduled for a pretrial today. It previously was indicated by the people that they were looking to add a malicious damage to building charge. I did speak with the assistant prosecutor this morning. My understanding is that it's still pending. They requested an expedited review of that. I'm just simply reviewing my motion to convert this to a personal bond with a GPS tether. Mr. Kirk has a address at 1775 Van Dyke in the city of Detroit, which is a friend's apartment where he could tether to with a and I have explained to him, and he would abide by no contact provision as well.
And yes, Your Honor, the advocate.
Hold on, I have two complainants here. Hold on, I have two complaining witnesses. Prosecutor 3 and Prosecutor 5, I need to move out. All right, I've got the two complainants also present in the courtroom now. So we were here last time on December 22nd to decide, or so the prosecutor can decide if they're bringing felony charges for a malicious destruction of building. And we were just discussing that when I realized that there were complainants present that I needed to bring in the courtroom. So is there any, who wants to fill in the rest? So he's requesting a personal bond with a GPS tether. Ms. Louie?
Yes, Your Honor. So the advocate did speak to the victims on this matter regarding what's going on. There is a review. I mean, there still needs to be a review on the felony warrant, but again, it hasn't been screened. I do want to bring it to the court's attention, however, defense did notify me that there is a few.
Right away, you can tell this hearing is about to get serious. The court is dealing with a pre-trial bond issue, and the defense is pushing for a personal bond with a GPS tether, which would allow the defendant to leave jail but remain electronically monitored. Now, here's the key question for the judge. Is there enough legal reason to keep him locked up, or does the law require releasing him with conditions? Watch closely, because this is where courtroom rules sometimes clash with public safety concerns.
A paper in the file that says prosecutor on there, and it happens to be some texts and I believe Facebook posts that were sent by the defendant's mom, who is apparently concerned that he may have some form of undiagnosed schizophrenia due to the way that he's speaking and texting people about God and other biblical things, and that she's in fear for him and for the community. I understand he is in custody and that it is the personal bond is being requested. If at the very least we can do a GPS tether, we do have two victims on this case who are afraid for their life.
I've had the opportunity to review that information as well. Obviously, it's not been authenticated, and I would certainly understand why it would be a concern. In my conversations with Mr. Kirk, he is not indicated to me anything of concern. Normally, if I saw those messages, I'd be looking at a potential forensic referral, but my conversations with Mr. Kirk, he's always presented appropriately.
Here's the problem. I cannot, this is the law. I cannot hold someone in custody because someone may or may not have concerns, and someone may or may not have an undiagnosed mental health condition. I do not have the authority to do that. It's against the law. I have to look at the bond rule, and this is what I have in front of me. I have an individual with no criminal history that's in on a misdemeanor charge, a 93-day misdemeanor. He's been in custody for since December 12th. He served a third of the potential sentence that he could get on this charge. I gave the prosecutor's office a week to make a decision as to whether or not they were charging a felony. I understand there are complaining witnesses in this case, but if the prosecutor's office has made a decision that this is a misdemeanor case, this man is not charged with assault with intent to commit great bodily harm. He's not charged with aggravated assault. He's not charged with assault with intent to commit murder.
Now, this is where things take a dramatic turn. The prosecution is bringing up messages from the defendant's own mother, suggesting he might have an undiagnosed mental illness. But here's the legal twist. Rumors or concerns alone aren't evidence. A judge can't legally hold someone in jail based on speculation or unverified messages. So the court now
he is charged with
potential
the lowest
safety concerns
level
versus the
assaultive
constitutional
crime
rule
someone
that
can be
people
charged
can't be jailed
with.
without
And I
proper
cannot
legal
hold
grounds.
an individual
What would
in
you do if
custody
you were the judge here?
because there are some unfounded allegations that this person might be mentally ill. If the prosecutor's office was that convinced that there was a serious threat of bodily harm to someone, they would have acted accordingly. And I don't have the authority to keep someone in custody by looking at the facts. There's no prior criminal history. There's nothing on his record that would indicate to me he's a flight risk. There's nothing on his record that would indicate to me he's a danger to the community other than the allegations in this case. And I cannot keep him in custody. I have to, especially when the prosecutor's office, and I understand it's over a holiday, but if this is such a grave concern, what are you doing?
Your Honor, I did request a GPS tether. If he were to be,
I'm giving him a GPS.
Okay. And just for the record, there are two complaining witnesses, which means there are two addresses. If
all of
the court needs them, I can supply them.
Mr. Kirk, do you hear and understand me?
Yeah, I'm listening.
Do you understand me?
You said you're giving me a GPS tether, correct?
Correct. Okay, so you know what's going on, right?
Yeah, I don't. Trust me, I won't go anywhere near them.
No. You listen to me. You listen to me right now. Mr. Rodney Myers and Ashley Austin are complaining witnesses on this case. And if I find out that you have gone anywhere near where they live, where they work, where they go to school, if you have any contact with them whatsoever, if you call them, text them, email them, talk about them on social media. If you have any contact through a third party and have your cousin or your sister or your buddy contact them, I will throw you back in jail. Are we clear?
Yes, ma'am. As soon as I get out, I'm going to block them on every social media, and I'm going to be in Detroit, so I'm going to be far away from them. Trust me.
Good. And you understand if they contact you, do not reply.
Okay. So
what do you do if you...
They won't get in any trouble if they contact me, just if I answer back?
Yup.
Okay.
Got it? So listen, say for instance, you're at a grocery store and you see Mr. Myers in the grocery store. What do?
I guess I leave, right?
You leave immediately. Got it?
Okay, makes sense.
All right. I'm going to convert the bond to personal with the GPS tether. What am I?
This is the moment every defendant needs to pay attention to. The judge has just laid out strict no contact conditions, and violating them, even indirectly through social media or a third party, can send someone straight back to jail. The GPS tether means authorities can literally track where he goes. One wrong move, one message, even replying to a text from the victims, and the bond could be revoked instantly. So the real question now is, will he follow the rules, or will we see him back in court again?
What am I doing? Setting this another week or two? I mean, I'm going to set it for January 21st.
Thank you.
Pre-trial January 21st at 9:30 a.m. Everyone can appear via Zoom. You're not to be within a mile of their residences. All right.
Do you know how long it takes to get the tether?
I do not. The county will get to you as soon as they can. I don't know. I would assume it's a few days.
All right, thank you.
Thank you.